Straker, Mr. Vassell-Adams, Ms. Mountfield, Mr. Purcell. It is with great sadness that the members and staff of the Supreme Court and the Judicial Committee of the Privy Council have learned the news of the death of our colleague and friend Simon Brown, Lord Brown of Eton under Heywood. Simon Brown had a most distinguished career in the law. At the bar, he rose to become First Treasury Counsel, Common Law, between 1979 and 1984. He was appointed a High Court Judge of the Queen's Bench Division in 1984, and in 1992 he was appointed to the Court of Appeal. In 2004 he was appointed a Lord of Appeal in Ordinary. He became a Justice of the Supreme Court at its inauguration on the 1st of October 2009. Following his retirement from the Supreme Court, Lord Brown was active as a crossbencher in the House of Lords, playing an important role in debates on legislation. Lord Brown will be remembered for his important contributions as a judge to the development of the common law, and for his legal learning, which was lightly worn. He was a man of immense personal charm and wit, and he is held by his colleagues and friends in warm admiration and affection. We extend to his widow Jenny, to Ben, Abigail and Dan, and to all their family, our condolences.
My Lord, on behalf of the Bar, may I, as the senior member of the Bar present, endorse your Lordship's remarks and express on behalf of the Bar our sincere condolences at the passing of Lord Brown, who was well known to many of us at the Bar, whether through cases against him or cases in front of him. And in cases in front of him, one always had to be on one's mettle because it was a frequent question as to what is your best point, please. And my best point about Lord Brown, which is a point that your Lordship has made, is that he was a man of charm and learning, and that he focused upon the justice of any individual case in front of him, which is the hallmark of a great judge, in my respectful observation. And indeed, my junior, in this case, Mr. Ramburn, Senior Counsel from Mauritius, had the honour of making the valedictory statement to Lord Brown in Mauritius after his last case in the Privy Council. And I have been informed that is now known in the Privy Council in Mauritius as the mango tree principle. I haven't been able to take full instructions as to what that precisely signifies, save this, that it represents, I'm told, a triumph of justice over some procedural hiccup which otherwise would have denied justice. And so therefore, on behalf of the Bar, I endorse your Lordship's remark and express our condolences to his family.
Thank you, Mr. Straker. Thank you all very much. Mr. Straker.
May it please the committee, I trust, if the committee will excuse me, and without disrespect to my learned friends, the cast list of counsel can be taken as read.
Yes.
I also take as read the respective cases which have been lodged, and I trust that the committee received last week a note from me indicating that there was a particular point that we no longer sought to pursue in front of this committee, namely the super cashback point. The committee has, of course, an electronic bundle in the usual way, together with a key documents file. I understand from my learned friend Miss Mountfield that you've been sent electronically a fuller copy of certain regulations to which I'll come in due course. And furthermore, we've caused to be printed out, in case it is of value to your lordships, a loose list of all the documents in the electronic bundle, together with the authorities, which in the list in the electronic bundle are simply identified as list of authorities. And we apprehended it might be useful to your lordships and my lady to have a copy of that.
Yes, that could be the assistance. Thank you very much.
Provided. My lord, I want the committee please first to look at page 1355 in the electronic bundle.
Just bear with us for one moment, if you would, please. I think we're all working off the updated electronic bundle of the 30th of June.
My Lord, yes.
Yes, thank you. Page
1355, and the committee should arrive at, or be at, a speech which was given on the 1st of October of 2019. And in considering this document, I ask, please, that this sequence of events be borne in mind. This speech was made on the 1st of October 2019. Dissolution of Parliament followed on the 6th of October 2019. The manifesto, upon which reliance has been placed in defence of the charge of bribery, was issued on the 23rd of October 2019, and the election took place, the poll took place on the 7th of November 2019. The committee will have had a chance to look at and to read through Section 64 of the Representation of the People Act, which is the provision as far as bribery is concerned. And in looking at this speech, as we're about to do, it is as well to have in mind, I respectfully suggest, that provision, Section 64, refers to any person who directly or indirectly, by himself or by another, promises to procure or to endeavour to procure any valuable consideration to induce a vote. All three of the respondents were present on the 1st of October to hear the speech which was made by the first respondent. And I don't need to turn it up, but it may have been noted in the electronic bundle at page 884 that the first respondent says, "I write my own speeches." Now, if one looks at this speech, which begins at 1355, and if you see it goes over a number of pages, it begins by referring to those who are present, who include ministers, members of the National Assembly, and so forth. And it also includes the President of the Senior Citizen Council, for this was a gathering of senior citizens. And if you go to 1360, this being the final speech that was made on the day, 1360, you will see that at about line 14, the first respondent says, referring to past events, "We kept our promise." Others were saying it couldn't be done, it would not be done. We kept our promise. We brought it, that's the pension, to 5,000 rupees, and the government is working. We have reached almost 5 years, because the committee will have noted that the 5-year period of time for the Assembly was shortly to expire. And so he draws attention to the fact that there must soon be another election. And we didn't get any problem. And then he makes what may be supposed to be a little quip about the President. The President had said, "Please don't touch our pension." And at line 19 he says, I don't agree with that. I can't do that, unfortunately for him. I can tell you that in our next mandate, next government, we will double your pension. We will bring it to 13,500 rupees. And then he makes an example of what that will constitute when you've got two people, elders, living in the same house over 60 years old. And then the speech continues at 1361. Therefore, let me tell you, you know my undertaking. You know when I give my word, as we had given our word in 2014, and that had been categorized by him as a promise. Some people have said it can't be, we can't make it. We increased year by year. This is my undertaking. 13,500 rupees during our next mandate, clapping. And then I don't read on, but you'll see towards the end of the speech, he says, you know, I am a man of my word, we will keep our promise, and together we move hand in hand so that progress can be continued, clapping, because together everything is possible. Thank you. And so we can see from that, the committee will appreciate from that, that these things were present in that speech. That is to say, a promise contingent on an event, namely a new mandate, in other words, an inducement to vote, a promise as to what he was trying to do, and a promise relating to money. And if one has in mind, quite apart from those clear matters, that this question, the question of pension, was always regarded, as no doubt it would be universally regarded, as a sensitive issue, and the committee may have seen in pre-reading, and I don't take up time in going there, at pages 949 and 950, when he was giving his evidence to the first respondent, that he recognises the question of pension as a sensitive issue. Now, with that in mind, could I invite the committee, please, to take the judgment which was given in Mauritius, which is found in the electronic bundle at page 397. It's also in the key documents bundle behind flag 7. And if you go to 417 at line 6 or thereabouts, you will see that the court agree that the announcement of an increase in BRP, basic retirement pension, had financial implications and represented money or valuable consideration. And then they go on to say, but they don't agree that the fact that a proposal, promise or measure to the electorate has financial implications and represented money or valuable consideration per se amounts to a bribery. And then if one looks on to the next page, 418, at the top of that page, line 1, the court say it was the promise of a future government. Now I pause to observe, parenthetically as it were, that it is difficult to see how a future government, not yet in existence, can actually make a present promise. It was the promise of a future government, not of an individual candidate. The announcement would have remained a mere statement of intention, not binding on any future government, if the respondents had not been elected and formed a new government. Even then, it would still have to be approved. And then it goes on, it wasn't the promise of an individual candidate directly linked to his own election, irrespective of the question whether his party formed a government or not. No quid pro quo or private arrangement between the respondents and the voters of constituency number 8, which was the constituency where he and his ministerial colleagues were standing as candidates, or came to stand as candidates. And then at 421, the committee will see at the foot of the page there's a paragraph which begins by contrast against line 23. By contrast, in the present case, the announcement of an increase in BRP was made openly in public to a crowd from all corners of Mauritius. It was not a covert announcement by an individual candidate, but a proposal of a political alliance contained in its electoral manifesto. And the committee will have in mind this is more than 3 weeks before the manifesto saw the light of day. It wasn't a decision but a proposal of an eventual future government. It formed part of normal electoral campaigning. Now, pausing there, I respectfully say that one can take from the judgment and those extracts to which I've just drawn attention, at least these points, that this was made to electors, that it was made as part of electoral campaigning, and I take electoral campaigning to signify an inducement to vote. Why else does one campaign electorally? And it related to a valuable consideration, related to money. And I ask in that regard one to have in mind, of course, the terms of section 64, to which I've already drawn attention. And I say that what this case actually shows is a struggle between the plain language of section 64, and that language is, with the greatest respect, absolutely plain, and the proposition that political parties or alliances of parties ought to be able to campaign as they please and make electoral promises in their manifestos as they please. Now, a number of matters arise quite clearly. A very clear criticism of the approach of the Supreme Court in Mauritius and of, with greatest respect, the respondents before the committee is the want of recognition of the distinction between a candidate standing for an election and a political party or an alliance. This can readily be appreciated by a number of factors, of which these are 3. First, section 64 is directed at any person. Ordinarily, a political party or an alliance of parties will be an unincorporated association. And in fact, once again, I don't ask the court to go there for this purpose, but simply to note that this is what it provides. The Constitution at Schedule 1, Paragraph 2, Electronic Bundle 1742, provides for political parties being associations. So that a political party ordinarily would not fall within Section 64. Second, in the law from which this is all derived, party played no part whatsoever. And I'll come to show the committee a mid-19th century case where the language for the definition of bribery is reflected in Section 64 in the Representation of the People Act with which we're concerned. But for instance, in the United Kingdom, it wasn't until 1998 that there was any legislative recognition of political parties, which was when political parties were first registered. And it wasn't until 1969, the Representation of the People Act 1969, that one was even able to have put on the ballot paper the attribution of party. Prior to that, one simply had to get by with describing oneself in terms that one chose. Third, in Mauritius, although political parties were acknowledged before the United Kingdom acknowledged political parties, they are done so for a particular purpose, so that a candidate can indicate which party or alliance he belongs to, or none, and have the name of that party or alliance and its symbol put upon the ballot paper for the benefit of the electors. And that's a consequence of the 2014 National Assembly regulations, which I mentioned earlier, which was the fuller copy has now been provided by my learned friend Miss Mountfield. With that in mind, I say that it is perfectly clear that the Supreme Court here in Mauritius committed a number of errors. Failure to distinguish between candidate and political party, failure to take account of the language of Section 64, and third, the determination that a case called Ringadoo in the Supreme Court in Mauritius provided the test rather than the language of Section 64. And can I develop that third point in this way by inviting the committee, please, to take first Ringadoo in the Privy Council at 2135, because the case came to the Privy Council from Mauritius, but it came on particular points. 2135, the committee will see the report as to what occurred, and I can take this very quickly because the matters which were at issue related to, as one sees from the catchwords right at the top on page 2135, standard of proof, and within the judgment that came to be given, there is a long discussion as to the appropriateness of whether it's civil or criminal. And then you see a reference to section 45 and 45(1)(c), and what had happened, to put the matter briefly, was that in India there had been a problem when Mrs. Indira Gandhi was found guilty under the legislation there, and retrospectively that was changed to enable certain things to be done if one was a minister during the course of an election. And it was that provision, or provision based on that, which came to be put into Mauritian law, but it is nothing to the point with which we're concerned here, and so that one can put on one side the decision in the Privy Council, because what happened was the Supreme Court in this case said we take the test which the court in Mauritius had provided for in Ringadoo, which wasn't, in terms of what bribery was, considered by the Privy Council here. And so if you go to 2344...
But the Privy Council didn't express any reservations about the Supreme Court decision.
No, they didn't, my lady, but it wouldn't have been necessary for them to, in the light of what went to the Privy Council, for them to have considered that or to express a view one way or another about the matter. And in any event, what took place in this case was that the Supreme Court in Mauritius said, we're concerned with bribery, what's the test for bribery, what does it mean? We look at Ringadoo in the Supreme Court in Mauritius and work accordingly. And so the judgment in the Supreme Court for Ringadoo begins at 2344, and if you go to 2354, you will see the statement, which might be thought to be somewhat curious, that bribery has not been defined in the representation of the People Act. But what would constitute an act of bribery can be culled from section 64 of the Representation of the People Act, which reads as follows, and then the committee will see the words set out which have already been mentioned. And then if one looks on in Ringadoo, at 2356, it is noted that the text of the law, 2/3 of the way down the page, 2356, text of the law is inspired from the English text, and English judicial decisions become a convenient and persuasive source for the interpretation of the law in Mauritius. I should point to, in their consideration of English cases 2360, a reference to Mr. Justice Blackburn as he then was talking about the meaning of corruptly. The word corruptly governs the whole with the object and intention of doing that which the statute intended to forbid. In section 64 with which we're concerned, the committee will have noted that in actual fact the word corrupt is simply used in connection with matters which might happen after the election to govern the circumstance of what would be the case if one was given a particular office in the ordinary course of events and someone said, well, it comes about because of the election. You need to show that it comes about corruptly in that case. Before the election, matters are different because you're concerned with what is actually being said and being promised. And then if you look on, 2363, the court say at the top of the page, we shall refer to Charler's Election Law and Practice, 6th edition, and that's a textbook from India dealing with these particular matters, and they arrive 2393, top of the page, considering whether such an act may or may not constitute an act of corrupt practice of bribery, and especially when done by a minister a few days before polling, we shall refer to Charler's election law and practice. And then at 2395, having cited some extracts, it is said, bottom of the page, it is clear from the above that it's only mala fide act with corrupt motive that would be censored. The test may be stated as follows. A candidate does not fall foul of our electoral law against bribery, where he is selling, so to speak, government performance or electoral programme or party manifesto to attract votes. That is normal electoral campaigning. The candidate must convince the voters why they should vote for him or his party. He would fall foul of the law when he is involved in buying votes, that is to say, exchange vote for money or any other valuable considerations instead of using cogent argument to influence the voters. There must be an element of bargaining, and the corrupt motive will stand out so obviously from the facts. Once the petitioner has put forward sufficient evidence, and then he says a matter of response to that. Now that was how that was put there, and if one goes back to the judgment in this case, you will see that at page 411 of the electronic bundle, within the judgment, for the purpose of determining the above issue, i.e. bribery, we find it apposite to refer to the following test laid down by the Supreme Court in Ringadoo, which is what I've just been referring the committee to. And then if the committee go over to page 413, the committee will see that there is a recitation of section 123 from the Indian legislation. Against line 22, the court note that the wording of section 123 is different from the equivalent of our own section of the RPA, i.e. section 64, but we're of the view that the pronouncements made by the Supreme Court of India in Balaji provide useful and relevant guidance. The court found that the promises made by the political parties in their election manifestos did not constitute a corrupt practice, and held as follows, and then there's italicized text. The gist of the appellant's argument is that promises of freebies, such as colour televisions, mixer grinders, laptops, etc., are in form part of an electoral manifesto of a political party, but in substance a bribe or an inducement under section 123. And then in the next paragraph, as appealing this argument may sound good, the implementation of this suggestion becomes difficult on more than one count. First, if we're to declare that every kind of promises made in the election manifesto is a corrupt practice, this will be flawed, since all promises made in the election manifesto are not necessarily promising freebies per se. For instance, the election manifesto of a political party promising to develop a particular locality if they come into power. Therefore, it will be misleading to construe that all promises in the election manifesto would amount to corrupt practice. Likewise, it's not within the domain of the court to legislate what kind of promises can or can't be made in the manifesto. And then there's a further paragraph saying some more about it, but it can be noted that at line 20, the court in India indicated that the provisions of the RP Act clearly draw a distinction between an individual candidate put up by a political party and the political party as such. The provisions of the said Act prohibit an individual candidate from resorting to promises which constitute a corrupt practice within the meaning of 123. The provisions of the said Act place no fetter on the power of the political parties to make promises in the election manifesto. So one's got that clear divide, and we have a clear circumstance here where we have whatever one thinks about a political manifesto which might say everybody is entitled to a free colour television. Whatever one might think about that, we have a clear circumstance here of a promise being made for the purpose of getting votes, which promise was outside completely the manifesto, because amongst other things, the manifesto had yet to be published. And I've already indicated that we can take from the judgment that all the ingredients of Section 64 are found to be present. But I say that the approach which they have followed displaces Section 64 and furthermore is inconsistent with the established position as to what the statutory words actually mean. And if I can ask you in that regard to look at the...
Before leaving...
I beg your pardon?
Sorry, before leaving the quotation at page 414, I think it's about line 15, there's a distinction drawn between the manifesto of a political party and the individual candidate. And it's asserted that it is not a promise of an individual candidate. That's a little bit unusual, isn't it?
Well, yes, it is possible.
Candidates usually promise to abide by the political manifesto.
Yes, I mean, it is the circumstance that it is perfectly possible for a candidate to say, I associate myself with the manifesto, or I promise that I will endeavour to do everything in the manifesto, or a variation on that. But that does not in any way overcome the difficulty of what happens when a candidate is speaking individually as a candidate and saying, this is what I will endeavour to procure. And furthermore, one can have in mind, we put it in the bundle of authorities. I don't want to take up time in going through it now, but there's a case called the London Borough of Bromley, and it's in the bundle at electronic bundle 1781. As I say, I don't want to take up time now in going through it, but where Lord Denning points out in clear and robust language that manifestos are all fine and large, but, if I can paraphrase, who reads them, who takes them into account, and in any event they contain within them a number of considerations, some of which may be in conflict one with the other, so how can you derive a clear set of promises from a manifesto? But I say it's rather by the by, the question of manifesto here, because we are so clearly in the circumstance of an individual who happens to be the Prime Minister saying, if I get another mandate, if I have another 5 years, and my 5-year term is coming rapidly to a conclusion, if I get another 5 years, this is what I will seek to do. And then that may happen to appear in the manifesto 3 weeks later, but contrast the circumstance of the person who is listening to that speech on the 1st of October, who goes away with that impressed upon his mind as to what has happened, do we know that that same person will read the 23rd of October manifesto? And if so, will that person take from it, well, all he was telling me on the 1st of October was what he was going to try and do, and now it's in the political manifesto, I should view somehow what he said differently. The position is one whereby it has been clearly provided for that candidates cannot do certain things. And one of those things they cannot do is make promises of a kind which shows you will get a financial benefit if you vote for me in consequence of what I will try to do. And remember, please, that we have this language in the Act of endeavour to procure, where we are looking at a circumstance where, by definition, someone is standing up and saying, if it comes to pass that I get into office, this is what I'm going to try and do. I'm going to try and help you out in this particular way. And the same holds true for offices and matters of that sort. Will you get some particular office of profit under the state? And so the whole matter is wrapped up in what you are trying to do, and that is then impacting upon the voter, who isn't choosing between the candidates on a basis of character of the candidates or past record per se of the candidates, but is simply distracted by what the law has said you mustn't allow them to be distracted by. And as I say, that has been clear since the middle of the 19th century, because if you go in the electronic file to 2445, you should find
Simpson.
That's right, Simpson and Yend. And I can't help but observe that at foot of page 2445, it said the facts of the case are given at length in the judgment. The judgment runs to about 3 pages. And so one has the benefit of knowing that the Victorians, to give them credit, knew how to deal with these matters. But what this was a municipal election, and because the system of petitions for municipal elections wasn't then in place, what one could do if one was concerned about bribery is go along to the court and say, so-and-so was guilty of bribery and should pay me a sum of money, namely £2. And if one, that's what happened here, and it was a promise that if someone turned up, he would be paid. And at 24447, you will see the statute which is referred to, which is the Corrupt Practices Act, and it's 1718 Victoria, chapter 102, makes it bribery. And the reason why I read these words to the committee is because they are so similar to what we have to do with today. Every person who shall directly or indirectly, by himself or any other person on his behalf, give, lend, or agree to give or lend, or shall offer, promise, or promise to procure, or to endeavour to procure any money or valuable consideration to or for any voter, it doesn't matter which constituency, or to or for any other person on behalf of any voter, or to and for any other person in order to induce any voter to vote or refrain from voting, or shall corruptly do any such act as aforesaid on account of such voter having voted, that's the situation after the election, then one is told one's committed the offence. And the judges in this case delayed giving judgment because they wanted to consult some other judges. And then over the page, you will see that they say, foot of the page, not distinguishable from Cooper and Slade, it is so important to the public interest that electors should be left free to vote without any disturbing influence of any kind, that we feel ourselves bound in construing the statute in question to give full effect to the plain meaning of the words used and to apply them to the substantial facts of the case without raising subtle distinctions or refinements as to the precise words or expression in which the promise or offer may be conveyed. And so there was a recognition clearly there that the court saw these matters as of very considerable significance and that one followed the plain language.
What had happened on the facts of this was a direct offer of money, was it, to an individual?
Yes,
Mr. Marshall was offered 40 shillings.
By the candidate.
Yes.
By the candidate, yeah.
And so it was effectively, if you turn up, I will give you some money.
Yeah,
I put it
lots of
rather
time.
crudely. But what we know is, from the terms of the legislation, that precisely what you do, so long as it can be put in terms of, is there some valuable consideration involved? The answer to that in this case is yes. Has a promise been made? The answer to that case, the answer in this case is yes. The court so fined. Is it an inducement? This was part of electoral practice. Therefore, this is how we work, and to get the votes in. And so one just sees that the terms of this section are met.
But the inducement in this case, or the inducement you're alleging, is not only to vote for this particular candidate, but to vote for sufficient numbers of people in his party, because the promise is absolutely valueless unless he actually gets a majority.
Well, that is true, of course, that one's dependent upon that, but when one looks at the language of section 64, it is promised to any person for in relation to electors, and it doesn't, in my respectful submission, matter that one's got this contingency in place, namely, will he secure a sufficient majority, or will his party secure a sufficient majority to enable him to still be Prime Minister? What matters is, what is he promising that he will seek to do, endeavour to procure? What will he seek to do? That's what he will seek to do. I will seek in that contingency. And it must be the case, my Lord, with the greatest respect, that in a vast number of cases, that the act of bribery, if there's going to be any possibility of fulfilment, depends upon the party or the candidate's friends being returned in sufficient number for the candidate to be part of the government thereafter. And because how could it be otherwise when you have matters such which are expressly referred to within the terms of the legislation as the provision of an office? So you contemplate the circumstance that there's an office of profit under the Crown. I use a conventional language for England. And the candidate is saying, that's what I'm going to try and get you. And now that will depend, of course, upon that candidate having been elected and sufficient of his friends alongside him forming the government to enable him to do that. But that's the promise which is made. So the fact that here the promise does, for fulfilment, depend upon a sufficient majority being secured for the political alliance is, I say, not in any shape or form determinative of the matter. Now, if one goes back to the judgment at page 415, we are picking the matter up after the reference to the Indian cases and the reference to section 123, and then there's a reference to a Supreme Court case from the United States, which was dealing with freedom of expression. And if one goes on to 417, there's agreement that the announcement of an increase has financial implications. We don't agree the fact that a proposal, promise or measure to the electorate has financial implications, and then goes on. And then at 418, as we've seen, it's the reference to the government. And then at 421, at the foot of the page, the last paragraph, by contrast, in the present case, the announcement of an increase in BRP was made openly in public to a crowd from all corners of Mauritius. It wasn't a covert announcement by an individual candidate, but a proposal of political alliance contained in its electoral manifesto. Well, on the 1st of October, that plainly was not the case. And in any event, why is it of significance that the announcement is made openly in public to a crowd from all corners? Reference, please, the terms of section 64. And what does it matter that it wasn't a covert announcement by an individual candidate? And then the point is made, it formed part of normal electoral campaigning. And so we can see that quite clearly the question of inducement was there. And they go on to say that the other party had also put into its manifesto something to do with the question of pension increase. Once again, I ask rhetorically, how does that bear upon these particular questions? So as far as 1st of October is concerned, I draw a line there, if I may, for the moment, because there are two other instances which I can take quite quickly. And if you just bear in mind for this purpose that the electronic bundle records at 894 that the manifesto came into existence on the 23rd of October 19. And then if one has the electronic bundle at page 908 and 920.
Just before we do that,
Yes, of course.
what precisely do you say means that this is not normal electoral campaigning? What are the features that you say point otherwise?
That it's not normal electoral campaigning. Well, I say that it's not normal electoral campaigning because it's plain and simple bribery. That's it. If one puts into the manifesto an electoral proposal, we intend to increase pensions by a significant amount or even by a given amount, and the courts have said it doesn't actually much matter whether one identifies pounds, shillings and pence or no. If one puts into a manifesto and then says, well, I associate myself with the manifesto that this will be our aim to secure increases in pensions, one's saying something very different from standing up as a candidate and saying, what I will try and do is to get into your pocket this sum of money come December the 1st. And that is what is being said. And so normal electoral campaigning may cover a vast range of activities, but it can't cover the circumstance of the candidate giving a bribe. And
so because you say it's what the individual is promising to do rather than promising to do on behalf of his party or with his party? Or...
Well, that's what the section says, my lord. Section 64 says any person who does these things is directed at the individual. It's not directed solely as a candidate. It's any person who does these things. And it's intended to preclude the giving of, amongst other things, money offers as an inducement to vote. And as I say, the distinction between the party on the one hand and the candidate on the other is profound because...
Who is making the money offer? I mean, where's the money coming from? It's not coming from the individual, is it?
No, it's not coming from the individual, but if one looks at Section 64, there's no reason why it should come from the individual, and if one reflects back as to the course of events which may have influenced those who drafted these particular provisions, one can readily contemplate circumstances where the candidate would say and be able to say, if I'm elected, I will endeavour to secure that the rents you are paying on the agricultural estates, which happens to be owned by my father, the Duke of Omnium, will be reduced, or something similar. And we have simply that language which would prevent that kind of episode, and it's provided for the situation today, when, of course, when it was drafted, pensions weren't even in the glimmer of anybody's eye, because they didn't happen until Lloyd George in 1906 and so forth. So we have a situation where we don't have to say that it's the candidate who's putting his hand into his pocket. It's simply, what is the candidate doing by way of a promise? And what am I endeavouring to procure? Now, if I can take your observation, my lord, slightly further, I would readily accept there are some promises given by an individual candidate which simply stand to be laughed at rather than taken seriously. The candidate who stands up and says, I think it's better we abolish working days and simply have every day a holiday. We can't have that sort of thing and treat that seriously, but this is something which could perfectly sensibly be treated seriously, because this was the Prime Minister standing up and saying, if re-elected, this is what I will endeavour to do.
Is normal electoral campaigning, does it fall foul of Section 64?
Normal electoral campaigning doesn't fall foul of Section 64, no.
Okay. And then what is the distinction between normal electoral campaigning, where you say, well, we're going to do this in the future, we're going to make available these funds for doing this, and that will benefit, for instance, selling council houses. How do you distinguish between the two?
Well, you distinguish between the two in this very straightforward way, I suggest. You've got your political programme, which contains your lordship's instance, the right to buy, the sale of council houses. And so you put that into your manifesto, and as a candidate you say, I stand with those other candidates with this political manifesto, and we will endeavour, as far as the manifesto is concerned, to pursue the manifesto. Now that can be contrasted, I respectfully say, with the person who stands up and is addressing the tenants of the Peabody building somewhere or other, who says, what I will do, if elected, is to secure that you are able to buy at discounted prices these flats which presently you occupy as tenants of the Peabody estate. And you've got a very clear distinction. You just have to have in mind what Section 64 prohibits and contrast that with what a political manifesto might say, because if one goes to...
So normal electoral campaigning would be generic. It would affect the whole population. Is that right? and as opposed to a specific bribe to a particular or a specific promise to a particular segment of society or a particular locality.
I mean, I hesitate to give to an expression as loose as, if I may put it that way, normal electoral campaigning.
You just accepted this.
Yeah, but the position is, one, what it doesn't include is Section 64, normal electoral campaigning. But normal electoral campaigning is that which can be done lawfully by all candidates at elections, including those who have no manifesto at all, the individual. And that includes the individual being able to say, I associate myself with a manifesto produced by party X or Y. But what the candidate can't do is to say, I will endeavour to procure a particular financial benefit for electors if I am re-elected.
If the election manifesto in this case had been published, the relevant manifesto published the day before the 1st of October 2019, would what was said have amounted to bribery on your case?
I respectfully say it would have still amounted to bribery on my case because it is so patent as to what is being said, and it is not simply saying I associate myself with the manifesto. It is, this will happen, this is what I will do.
So if the first respondent had said on the 1st of October, as set out in the manifesto published yesterday, I undertake to stand by it and procure this benefit if elected, would that amount to bribery?
The answer to that question is yes, it would, if he's saying in express terms, contrary to what Section 64 indicates can legitimately be said, I promise you X for the purpose of inducing a vote.
So have you just eliminated all election promises in relation to pensions?
No, I wouldn't say I have eliminated pension promises at all, because the parties are still able to say in their manifestos, we think that the age for pensions is set too high or too low or whatever it may be, and therefore that is going to form part of our consideration in our administration if we are elected.
Well, wouldn't the electors like to know what they're voting for?
Yes, and the politicians can say in our manifesto, this is what we have said we contemplate doing. But what they can't do, I say, is as a candidate, is to say, you will receive this financial benefit if you vote for me. We've got to be able to put Section 64 alongside the situation of political campaigning. And in order to do that, one must recognise this distinction between the candidate and the party, and one must also recognise that Section 64 is in clear terms as to what can and can't be done.
Mr. Straker, in the example you gave a moment ago in relation to the Peabody flat, the promise of the benefit was specific to the recipient. Is it relevant to the way in which you put your case that if, in the present case, the individual had been elected and the party had become the party of government, the benefit would have been conferred on everybody within a very large class who qualified, all pensioners?
What is relevant to my argument is whether or not there are identifiable persons to whom one can see this is an inducement to vote. Refrain from voting, this is an inducement. And so if you're doing something which is so absolutely broad that it can't conceivably be to any group an inducement, then it may be what your lordship is indicating would be that well, that wouldn't constitute and couldn't constitute bribery. But it doesn't matter the size of the group which is actually involved.
Does it have to be specific to constituents?
No.
Those with the power to influence the outcome of the election in that constituency?
The position is one whereby what is said in section 64 is that it's a matter of making a statement, making a promise, which is made, which can have the effect as far as electors are concerned. So that is the position. You have section 64, of course, set out in the judgment. And for the purpose of answering my lord, it is maybe as well for me to go back to that, because at page 407 in the judgment is set out in the electronic file the terms of the section. And there the endeavour to procure is for an elector or for any person on behalf of an elector or to or for any other person in order to induce the elector to vote. Now, plainly here we are not talking about a singular elector, but if you've got a circumstance where you can properly say what are you trying to do, provide money or valuable consideration for electors or to persons on behalf of an elector or to any other person in order to induce the elector to vote, so that it may be that one says, I'm going to do something which is entirely out with my particular constituency, but it has a financial benefit in order to induce the elector to vote or refrain from voting. And furthermore, there's no requirement there, in fact, that the elector in mind is as an elector in the individual's constituency.
What have the second and third respondents done? They attended a meeting at which a speech was made. What else?
Well, they, I say, effectively ride on the coattails of respondent one.
How?
Because they stand by him and campaign, and I have a reference, if your lordship will forgive me, as to it being recorded that they were participating in the exercise.
As far as the 1st of October 2019 is concerned, had they done anything at that event?
Beyond being present?
Yes.
No.
And does being present suffice?
Simply being present by itself, I think I would have to say it would not suffice. It could not suffice, because if one, the evidence is that he was speaking without having revealed to others what he was going to say. So I couldn't sensibly say R2 and R3 simply by virtue of the fact that they were alongside can be tainted by that. What I do say, as far as they are concerned, R2 and R3, is that here we are in constituency number 8, where you return 3 members to constituency number 8, and they proceed through the election alongside respondent number 1, so that when one looks back at bribery, any person who directly or indirectly by himself or by any other person.
And what's the indirect? What do they indirectly do?
Well, indirectly they are, so to speak, standing by, but they are by any other person proceeding in that way set out in section 64.
So what, the first respondent is acting on their behalves, is he?
The first respondent, when he gave his evidence, certainly indicated that he could speak on, so to speak, their behalf, but as far as that is concerned, the position is one whereby one's not looking directly, my lady, to see, is this a matter of one being able to say, there, so to speak, is someone who is my agent or acting on my behalf. One's simply saying, is there a person who by another person on his behalf is endeavouring to procure? And what was respondent number 1 doing, if not on his own behalf and on behalf of the other 2 candidates?
Mr. Straker, it occurs to me that you've got some way to go in your submissions
I'm conscious
very,
of
very,
course, of
very limited time.
Yes. My Lord, can I therefore deal quickly with the other matters, which are the 2 other instances of bribery, and I can probably best do this, I suspect, from the judgment. If you go in the judgment to 424, you will see that it's recorded there that the respondent number 1 announced at a public meeting on 15 October 2019, so it's still before the publication of the manifesto, that there was going to be a payment of a one-off performance bonus to police officers, firemen and prison officers. And then in terms of the other circumstance, if you look up the page on 424, the PRB report would be accelerated. Respondent number 1 announced that the PRB report would be implemented as from January 2020 itself. And so if one just pauses to contemplate the circumstance, what was happening was that the respondent number 1 was stating, both in respect of the PRB report on the 23rd of October and in respect of the bonus on the 15th of October, that these matters would occur. And so that we have, if we then look on, the circumstance at page 430, a record of, in the middle of the page, those proposals relating to the PRB report being made openly in public and were contained in the electoral manifestos. So in each of these instances, one because it preceded and the other because there were 2 concurrent matters happening, that the exercise was one whereby the circumstance can be described in like terms to October the 1st. Can I just, before I move to the question of treating, which is what actually happened on October the 1st, give the committee a reference whereby at the electronic record at page 935, it will be seen that he was speaking on behalf of others as far as the case was concerned. At page 626, R2 and R3 are recorded as present, I believe, and at 474, 475, they both being ministers, R3 is recorded as the Minister of Technology. Now, in the time that remains to me, my Lord, can I then turn to what is, so to speak, the fourth question, which is the question of treating, and this proceeds under a different provision, which is set out once again in the judgment. At 441. Where 441, my Lord.
Yes.
At line 20, section 64.
Yes.
Subsection 2, any person who corruptly, by himself or by any other person, pays the expenses of giving or providing, indirectly gives or provides, or pays the expenses of giving or providing any food, drink, entertainment for the purpose of corruptly influencing that person or any other person to vote or refrain from voting at the election. So this provision, in contrast to the bribery provision, does actually include within it the adverb corruptly. And there, what the position that has been reached as far as the courts are concerned, in my respectful submission, correctly reached, is this, that what matters is what is actually happening and the time at which it is happening, from which the conclusion can be drawn. And this can best be seen from the Kingston upon Hull case, which is electronic bundle 2171. Now, the committee will see that this is a case which happened following the second election in 1910, and it happened in circumstances where it is made patent that the judges did not want actually to come to the conclusion to which they came. And you will see that at page 2172, it is recognised, middle paragraph, Sir Henry Seymour King can very fairly and properly claim to have recognised the requirements of the poor of Central Hull. I'm not suggesting for a moment that he's done it wrongly or improperly or with any other motives than a proper one. I don't believe he has. I think that when he told us that he never had given anything to a voter in Hull with the intention of getting his vote, he told us nothing but the truth. I think that was a true statement. I accept all that. And I think, without going into the question which Mr. Foote has raised as the particular amount of poverty or distress, that we should not have found anything in that which had been done by him which would have an improper complexion upon it, had it not been for what took place recently and at the time of the last election. Had there been no prospect of an election, what has been done by Sir Henry Seymour King was no more than was done at Plymouth. no more than is done in other cases, which we presently quote at length. But an election was in prospect, and it is in that way that this matter has arisen. And then, if you look at the following page, page 2173, in the middle of the text, having referred to submissions made by Mr. Dickens, it seems to me the true answer is what I'm about to say. You assume for a moment that a man forms a design which at the time is unobjectionable because no election is in prospect, and this was to be a celebration of his 25 years as a member. Yet if circumstances alter and an election becomes imminent, he will go on with that design at his risk, and if he does so, he will be liable to be found guilty of corrupt practices. That is to say that he has done a thing which must produce an effect on the election, contrary to the intention of the Act of Parliament. And then he goes through certain matters which I can take as read, but we get to page 2187, where we're in the judgment of Mr. Justice Bucknell now. That great lawyer, great judge and master of the English language, Lord Byrne, then Mr. Justice Byrne, delivered that historical judgment where he said there should be no charity at times of political warfare. Why? The reason is obvious, because whilst you, the donor, may be gratifying your own charity and doing a kindness, doing kindly acts to others, you may be doing a great injustice to your opponent. You may be doing what he is not. You put yourself on another plane and on another pedestal from that on which he is. And it's unjust to him to give while he is not giving, even although you may have a motive of kindness and generosity, or a desire to celebrate your own 25th year of political life in the division in which you and he are engaged. You, the respondent sitting member, and he, the man who desires to get your place. Mr. Foote put it well, it wasn't fair to Dr. Ask. And the court here, in fact, recorded how the question of corruptly is indicating that one's avoiding that which Parliament has provided should not occur. And in this circumstance, what happened was the chronology that the committee has, and the detail of that event the committee has, a large number of people attending, an election imminent, in circumstances where the defence given is, well, I may have been the Prime Minister, but I was simply a guest at this exercise, and the position is one whereby, so to speak, I couldn't stop it if I wanted to. The position is twofold. One, that of course attendance was not compulsory, and in any event, it is not sensible to assume, in my respectful submission, that the Prime Minister, who held a variety of other offices at the time, was not in a position to say to the Ministry of Social Security, I think it was, who organised the event, look, Parliament is about to be dissolved. I know that because it's in my gift, October 1, October 6. In any event, Parliament's only got a 5-year life, and the last Parliament started more or less 5 years ago. We better not do this. I take the risk, and that risk has come back, I say, in circumstances now, to bite the respondent. My Lords, I've taken that at some degree of pace, but those are the submissions that I want to make on those 4 topics which I've left in for the committee to consider. So I'm much obliged to the committee.
Thank you, Mr. Straker. I don't think there are any questions for you at this stage. Thank you. Mr. Vassell-Adams.
My Lady, my Lords, our case on this appeal is that the Supreme Court was right to dismiss this election petition for the reasons that it gave in its thorough and well-reasoned judgment. And the appellant has not identified any genuine legal error in the Supreme Court's approach. The appellant's central contention on this appeal is, with the greatest respect, obviously misconceived. In a nutshell, this case is concerned with electoral laws prohibiting genuinely corrupt practices, such as bribery and treating, which the appellant seeks to extend to encompass statements made by an election candidate promoting his party's policies during an election campaign. The appellant seeks to treat such statements as bribery simply because those policies would confer a financial benefit on a certain class of voters if the party were elected to government. But this is true for many of the bread and butter issues of politics, from pension rates and public sector pay, as in this case, to income tax cuts or benefit rises. To extend the law of bribery in the manner contended for by the appellant would make ordinary election campaigning impossible. The appellant's interpretation of Section 64 of the Representation of the People Act encounters, we say, three fundamental difficulties as a matter of law. First, it fails as a matter of statutory interpretation because it fails to give effect to the ordinary and natural meaning of the relevant words. Secondly, it would infringe the respondent's constitutional right to freedom of expression. And thirdly, it would undermine the constitutional principle of free and fair elections. I will develop these points in my submissions. By reference to the factual background to the judgment, now that two of the original grounds of appeal have been abandoned en route, this appeal, so far as it concerns bribery, now comes down to three allegations, all of which relate to statements made as part of election campaigning in the run-up to the 2019 National Assembly election. And the three policies were all part of Alliance Mauritien's 15 key measures in its election manifesto. And I will just give your lordships the reference. It's hearing bundle, page, electronic bundle 1448. I won't take your lordships to it. The judgment provides some very helpful factual context for each of these proposals. Firstly, in relation to the basic retirement pension, we can just briefly pick up the judgment, please, at page 415. And if we go to the bottom of the page, please, it's the paragraph starting in this respect. And it points out that the increase in the BRP was one of the 15 key measures in the electoral manifesto. And it reiterated a public announcement that the BRP would be increased to rupees 9,000 from December 2019 and to 15,500 in the next mandate. And that's a reference to the announcement that was made on the 1st of October. It was one of the prime subjects of the election campaign. And the court noted that the Alliance Nationale, to which the appellant belonged, also had a manifesto proposal to increase the BRP, in its case to rupees 10,000 from December 2019. Turning to the second paragraph on page 416, please. They explain the importance of the policy in the context of the political campaign, namely that this was a proposal to increase the BRP was a continuation of a prior policy adopted in 2014 by the incoming government of which the respondents were part, which had already increased the BRP up to 5,000 rupees. and that indeed on numerous occasions before the 1st of October 2019, the first respondent had stated his wish to increase the BRP to the minimum wage level, which was 9,000 rupees at the time. So that's the factual context for the proposal in relation to the basic retirement pension. Now, staying with the judgment, please, if we could look at the Pay Research Bureau report. If we go, please, to page 426. And at the very bottom of that page, the two lines starting, "there is no doubt," the court points out that there's no doubt that that was a recurrent theme in election campaigns for general elections in Mauritius, and that again it was a theme of the 2019 general election campaign. On the following page, that it featured as one of the 15 key measures in the Alliance Mauritienne's manifesto, and again that a similar proposal was put forward by the Alliance Nationale, where it promised in its manifesto that the PRB report would be published every 3 years instead of every 5 years. It also undertook, this is the Alliance Nationale, to request the PRB to consider the disparity in the salaries of different categories of public officers following the introduction of a minimum salary and to review their salary scales. So once again, both parties were campaigning on issues relating to the PRB report and how it would be implemented, and proposing that different groups would benefit from their proposals. The same was true of the performance bonus, and if we can see this from the bottom of the page, on page 427, please. Sorry, it's at the bottom of the page, on page, yes it is, on 427. I apologise. So that was the PRB report. And then in relation to the performance bonus, page 429, please. And we can see on page 49, on the third paragraph on that page, there was a performance bonus. The Alliance Nationale was proposing a performance bonus for police officers, firemen and prison officers, that indeed that had been a recommendation of a PRB report in 2016. And indeed, there were equivalent proposals that the Alliance Nationale had, whereby it promised to pay a performance bonus to police officers, again with a retroactive effect of 2 years. Now, my lords, the appellant has never actually addressed how the policies which he contends were bribery in the mouths of the respondents would not also make him guilty of bribery for advocating similar policies of his own. And under cross-examination, the best that he could come up with was, well, 2 wrongs don't make a right, or that in his party's alliance's manifesto, it was simply a manifesto promise, but it was bribery in the respondents' manifesto. And one can see what the Supreme Court of Mauritius thought of those responses. I think it would be fair to say it was decidedly unimpressed. It's at the bottom of page 428, where the court says, "We must say that we were not impressed at all by the petitioner's astounding answers and double standards." Turning, please, to section 64 itself, I'd like to start by saying something about bribery and treating. These were, of course, common law offences before they entered any statute book, and such offences were commonplace in this country in elections in the 18th and 19th centuries. And in the Earlham and Ranham case, which is in the bundle, it is pointed out that in the 19th century, bribery literally involved handing money over to voters or offering them jobs, and that typically the kinds of candidates then standing for election in those days often had jobs at their disposal. For example, major landowners or captains of industry. Treating involved plying voters with food and drink. And the reason that these corrupt practices were quite efficacious in those days is because there was a very limited electorate, and the fact that the poll was still an open declaration of vote right up until the 1860s. In other words, voting took place by a show of hands at a hustings, so that if you had, it was readily ascertainable whether you had successfully corrupted someone by promising them a job, because you could see whether at the hustings they would raise their hand. And what, of course, happened then was a major change in the law in the form of the Ballot Act 1872, which introduced the secret ballot. And although, as the law reports demonstrate, attempts at bribery are not unheard of nowadays, the much larger electorate and also the fact that the ballot is secret have made it much rarer. My lady, my lords, the relevant provision of the Act is in the bundle at, in the authorities bundle, please, at page 1761. And this is section 64 of the Representation of the People Act 1958. And this provision, in its simplest form, is directed against candidates buying the votes of their constituents, paying them money or valuable consideration in order to induce any elector to vote or refrain from voting. And in our submission, it is a provision that must be construed with both care and rigour, given that the consequence of a finding of bribery is so drastic. Because once there's a finding of bribery, an election must be voided, and there is in fact no requirement to show that it was likely to have affected the result of the election. So if there were clear evidence of someone attempting to bribe 3 voters and that candidate won by a margin of thousands of votes, their election would still be voided by that conduct. Now, in our submission, the words "in order to induce any elector to vote or refrain from voting" are crucial, because they turn what would otherwise be merely a promise to confer a financial benefit on a person into a corrupt promise or bargain that money will be paid in return for a person voting in a particular way. And yet, if one looks at my learned friend's written case, which addresses the question of statutory interpretation at paragraph 17, it makes no reference at all to these words, "in order to induce any voter to vote or refrain from voting." And by excluding those words from consideration, wrongly, clearly wrongly in our submission, it enables the appellant to argue that a promise of money or valuable consideration, howsoever made and in whatever terms, amounts to bribery. And that really is how we make the appellant makes the giant leap to contending that campaigning for a policy that would confer a financial benefit on a certain class of voters amounts to bribery. Now, of course, a crucial distinguishing feature between true bribery and election campaigning is that in the case of the former, the candidate's corrupt promise is made in anticipation of receiving votes in return in his constituency. That is the essence of it. You make the promise of money to voters in your constituency and they vote for you in return. But with a campaigning promise, this causal element is missing. When the respondents promised to increase the level of the basic rate of pension, if elected, that financial benefit would accrue to every retired person in Mauritius, not just the constituents of constituency number 8, and indeed whether or not they voted for the Alliance Mauricienne or not. Now, what makes bribery corrupt? What makes it corrupt for an individual candidate to seek to advance his own electoral prospects by making or promising to make a payment of money in order to get a vote, is because the promise of material gain undermines the ability of those voters to exercise their free will when voting. But the free will of voters is not undermined by any number of campaigning promises. Indeed, the whole purpose of an election campaign is to enable voters to choose between the rival policies of the competing parties. So in our submission, the kind of open election campaigning with which this case is concerned is simply not caught by Section 64 at all, and applying the ordinary and natural meaning of the relevant words, it simply isn't bribery within the terms of that section.
How do we identify a campaigning promise as opposed to a corrupt promise? Is it the breadth of application of the promise, or is it the way in which it's made?
I will come to the criteria which we say the Supreme Court of Mauritius correctly applied in that regard, and the factors that it had regard to in a moment, if I may.
Right, thank you.
I think they'll come more helpfully at the relevant stage of my submissions, if I may. Before I come to that, to say something about corrupt intention and the meaning of corrupt. Now, one of the features that my learned friend referred to about Section 64, is that with regard to gifts or promises made before an election takes place, there is no reference to the making of a corrupt gift or promise. And the lack of the legislative use of the word corrupt in this context was considered by Baron Fitzgerald in the Borough of Limerick case, and that's Electronic Bundle 2597. I'm not going to take my lords to it. In that case, bribery was not established. It is in fact a case about treating. So what is said about bribery is strictly obiter. The relevant passages are extracted in the judgment at pages 409 to 410. Now, in summary, what Baron Fitzgerald said is that the absence of the word corrupt was because the court could draw a prima facie reasonable inference that the act in question was done for a corrupt purpose, with the onus then falling on the opposing party to rebut that inference. But conversely, when the word corrupt is used in the statute, Baron Fitzgerald suggested the legislature didn't intend that the act itself should give rise to an inference that it was for a corrupt purpose. But the key point to note is, in both instances, a corrupt intention is required. Whether you get there by way of the drawing of a reasonable inference from the facts, or whether the statute expressly says corrupt, in both cases a corrupt intention is required. And of course, both bribery and corruption are defined as corrupt practices in the relevant UK legislation, the UK equivalent to the legislation that we're considering here. Now, precisely what is meant by corrupt is never very satisfactorily explained in the authorities. In a number of cases, and one was referred to by my learned friend this morning, it said that corrupt means doing what the statute prohibits. But that does tend to rather beg the question. The Britannica dictionary refers to corrupt as meaning doing things that are dishonest or illegal in order to make money or to keep or gain power. And that, in our submission, comes close to what the legislature had in mind in this context. Ultimately, however, whether a given act or a given promise is corrupt is a question for the court trying the election petition to be decided in the light of all the facts. And therefore, whether a reasonable inference can be drawn that a given act or promise is corrupt is going to depend on all of the factual circumstances. Now, as we've heard, my lords, some of the 19th century cases literally handing out money to voters on their way into polling booths. But we have more recent examples. For example, in the Jugnauth v. Ringadoo case, electronic bundle 2344, creating a false expectation that voters for a party would get jobs in the civil service was corrupt and indeed bribery. Or in the Earlham v. Rahman case, electronic bundle 1906, improperly targeting mayoral grants towards a particular ethnic group that was singled out for political support. But in our submission, no such inference, no reasonable inference can be drawn from the fact of making open promises in the course of an election campaign that such promises are corrupt. My lords, this isn't the first time that the Supreme Court of Mauritius has had to consider Section 64 in the context of promises made in the course of an election. And we were already taken to the key passage from the Ringadoo case, which appears in the judgment at page 411. And that was if my lords would turn up page 411, we have the quote set out there. And what the Supreme Court of Mauritius is saying there is, you know it when you see it. You know the difference between bribery and normal election campaigning when you see it. It isn't purporting there, as my learned friend suggested, to offer up some kind of definition of bribery. That's not what it's doing. What it's saying is there is an obvious and real distinction between the sort of open campaigning where you're trying to persuade voters of the merits of your policies and trying to buy votes, persuade voters to vote for you in your individual constituency by offering them a bribe. Now, the Supreme Court of Mauritius also found it helpful to gain some, to look at two interesting judgments of the US Supreme Court and the Indian Supreme Court. And I'm going to come to those next, and then I will be coming to my Lord's point of the criteria by which we seek to distinguish bribery from normal election campaigning, because the Supreme Court of Mauritius derived some of those criteria from those that feature in the judgment in Brown v. Hartledge, the judgment of the US Supreme Court. I can see I've got about 3 minutes, my Lord, till 1 o'clock.
We're in your hands, Mr. Vassell-Adams.
I think as I'm moving to a new chapter, as it were, I will start again at 2.
Very well. We'll adjourn now. We'll resume at 2 o'clock, and you will have until 10 minutes to 3 to address us. Thank you very much.